Law Simplified with Justice, the new informative, educative, and thought-provoking program is what you need to keep abreast with law and politics. This exciting and truly refreshing program is anchored by Justice Maduforo, a solicitor.
Ladies and gentlemen, it's been a soul-searching discussion here with my colleague. We've been dissecting sole responsibility under the individual rule, those under 18 and those above 18 years of age as well.
Law Simplified with Justice understands that law is a powerful driver to human behavior. It is therefore poised to simplify the law and get you to take action.
We'll bring it to your doorstep and simplify it the way that you will understand.
Contact Justice by calling 07931 727 597 or email lawsimplifiedwithjustice@yahoo.co.uk. Law Simplified with Justice, bringing the best to the audience.
You mentioned about the routes whereby one can take to get to a point where he can now apply for indefinite leave to remain. One of the you mentioned is the 2 years, you mentioned the 10-year rule, you mentioned the 14-year rule. Obviously, until the 14-year rule kicks in, at this point, that means it's still practicable to lodge the application now. Now, what can an applicant who has lived there in the United Kingdom for 14 years, illegally, no papers, probably have no existence in terms of his name anywhere in the United Kingdom, but has constantly, physically lived here for 14 years. How does this individual go about proving his existence here?
Yes, certainly. From practical point of view, as a practitioner myself, and indeed I have come across a situation, and I tell you, it is tough. It's not easy, because the rule actually requires that you actually prove that you have been in the UK for that length of time. And in any event, a lack of evidence obviously creates doubts. But nonetheless, if you're able to actually somehow convince the authorities that you have lived here, of course there are so many ways you can do that, not necessarily by having 100 documents. But what they're looking for, honestly, the documentary evidence from the reliable sources, which can actually, even if it's 4, 3, perhaps from your GP, or perhaps from a reputable organization, or perhaps from hospitals you have attended, or schools, or something of that nature, very well organized, reputable company that Home Office can contact to say, oh, you said this individual has been in this country, or you've been as a GP, for instance, or hospitals, a consultant who can write a letter if there is something of that sort. Say yes, and they can verify that source. That is obviously acceptable.
Yes, it is one of the news, which you rightly mentioned. But a viewer watching here today want to say, wow, how can I prove what this reputable organization you just mentioned? Because over times we've seen a lot of applications or people come forward to us, and simple question put as in, can you give us information regarding where you've lived or worked or anywhere at all? The answer has always been, I don't have any existence here. Obviously, I don't want to use the other part, whereby it may not be right for us to use that on air here. But this individual don't have any existence. To have worked in any reputable organization, as you mentioned, and just simply existed, but has managed to stay on here for 14 years. Remarkably, it seems very impossible for one to spend 14 years without any proof to show that. How individuals who fall into this circumstance now, especially hanging on that 14-year rule, what is other better way to deal with this? Because it seems that we cannot exhaust so many areas where they can need to prove that. We always throw it up to them to come and meet a lawyer and come to us after this program, see what by taking instructions and how and where they've gone to, be able to piece one or two missing souls, and then be able to advise and say this is the way it could go. But a situation where you found that, how do you go about advising or dealing with this without giving you advice, because it's your opinion now? So how do you deal with that?
That is why the circumstances differ, and it's impossible to actually say it on air, because you need to have an opportunity to actually have one-to-one with the client, be able to ask. Because I can tell you, and that's the point Home Office takes. So you live in this country for 14 years, you do not have documentary evidence. It's just like, what? It's just impossible. Yeah. So, of course, there are ways. You may think that you do not have documents, but you do have documents. But you may not know how to get these documents.
Yes.
And that's when you need a lawyer to obviously sit down with you ask you certain questions which will lead
Absolutely.
to getting certain answers. Because one thing about law is not mathematics. There are always ways.
Right. Okay. In those circumstances whereby we've not dealt with one of the 14-year rule, obviously, the last section of this program, we were talking about point-based systems on different tiers of the point-based system. We talked about the tier 1, tier 2. No, we talked about those of them, obviously. The idea of this program today, was to discuss the part 2 of that. Now, dealing with indefinite leave to remain, obviously, there are still leeways whereby people who are under tier 2, for instance, can still apply. Obviously, we mentioned those 10-year rule, which is basically students who have been living here and then extending their student visa up to the point it gets to 10 years, they're eligible to apply for indefinite leave to remain. Now, circumstances where tier 2s also, they are also available. This route is also available for them to apply. By the time they clock a certain years, they can apply for indefinite leave to remain. For those of them who have these applications, how many of them through the tier 1 or tier 2, tier 3, I understand it's 5 years which they must have stayed here before they can be eligible to apply that. Now, how do they go about doing that? Having clocked up, some of them are not yet clocked up 5 years. Some are still below 4 years. Some are still about to clock up 5 years. Well, because their visa is expiring before 5 years interval, because I've really got this, dealt with this particular example where an individual under the tier 2 has clocked up to 4.5 years. By the time the 4.5 years were expiring, the visa has expired, leaving a gap of 5 months, for which to clear and become 5 years at a stretch. At that stage, how do you deal with this matter like that? Again, it's not up to 5 years.
This is indeed a very, very crucial point you just mentioned, because myself, I've come across it. But individual circumstances differs. So the best bet is actually seek proper legal advice to speak so that we can actually take further instruction from you. There are many ways you can actually achieve that. Just like I've said in relation to this 2-year, 10-year, and 14 years. Of course, there are other ways to even get permanent residence under the EU route for the European citizens. So in that respect, assuming that if married to an EC national and under what I call 5-year rule, 5-year rule with divorce and 3-year rule with divorce. 5-year rule, which I call if you obviously married to an EC national and live with your spouse for 5 years, and your spouse and yourself are exercising treaty rights. So after 5 years, you can apply for
this is under the EEA now.
Yes, under the EEA.
Right. But the UKB always use that word, permanent residence, rather than using the indefinite leave to remain.
Yeah.
It's a matter of terminology.
Yes, certainly.
Absolutely.
So there was in relation to, obviously, I call another 5-year rule. 5-year rule, because it's very important to actually clarify these two 5-year rules with divorce, which is to say, when you have actually continued to exercise 5-year EC right, after 5 years, and you divorce, that's not the end of the matter.
Right.
It can still apply, but you and your spouse has to be actually exercising treaty right for 5 years, and it's still divorced. It can still apply. One of the rules that I just came recently is that you don't have to be living with your EA national. As long as EA national is exercising treaty right in the UK and you live in the UK, you could be living in a separate address.
I'll come to that. That's another huge topic for us to dive into. So, but for the purpose of streamlining it down to those who are entitled to apply for indefinite leave to remain, obviously, you've mentioned the 5-year rule. This from those from the EEA, because they are definitely covered under the European laws, not under the British law. So that's why they use the term permanent residence application. And then for those who are coming under the immigration or the UK immigration laws, and I use the term indefinite leave to remain. So whichever way, it's still the settlement we're hitting down to. Okay.
Yes.
Now, someone who has acquired this indefinite leave to remain, the next step of application is having been granted indefinite leave to remain. That is another stage, is it?
Indeed. This stage obviously have to naturalize,
Right.
Yes. That is to say, applying to become British citizens.
Law Simplified with Justice, the new informative, educative, and thought-provoking program is what you need to keep abreast with law and politics. This exciting and truly refreshing program is anchored by Justice Maduforo, a solicitor.
Ladies and gentlemen, it's been a soul-searching discussion here with my colleague. We've been dissecting sole responsibility under the immigration rule, those under 18 and those above 18 years of age as well.
Law Simplified with Justice understands that law is a powerful driver to human behavior. It is therefore poised to simplify the law and get you to take action.
Bring it to your doorstep and simplify the way that you will understand.
Contact Justice by calling 07931 727 597 or email lawsimplifiedwithjustice@yahoo.co.uk. Law Simplified with Justice, bringing the best to the audience.